Fisher?
Mr. Chief Justice, and may it please the court, wholly apart from the company's legal interests here, the Act directly restricts the rights, the First Amendment rights of American creators to participate and speak in what the court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the Act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the Act fails that test, and indeed any level of scrutiny under this court's case law, because the Act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with its implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we have faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
How exactly are the creators' speech being impeded?
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other Americans.
But it doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with that
using that
publisher.
argument, you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X or the current owner of Fox News or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.